Clerk calls the case to reverse the charge Young.
Alexander on behalf of the people, Your Honor.
Defender appearing on behalf of Mr. Young. Approaching, state your name.
Rashard Young.
Your Honor.
Yes. Okay, if it's you, Miss Linda, okay.
25,000 without the 10%. In this case, the defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV and assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we would be asking that at this time his bond is set at $25,000 without the 10% into custody, Your Honor.
Response.
Okay, regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through that evidence and possibly at that point we can, address bond again at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
Your Honor, I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, your phone was on. Did I give you the iPad? It is my understanding that he is gainfully employed. He is a father. I would ask if he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day. Mm-hmm. But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those out I'll send an email to have those released today.
I'm going to set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the $25,000 with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's going to be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked so that he'll go into the jail. He won't have phone privileges. This is the court's intention. And then you can get those through with your client and we can figure it out next week. But at this point, defendant's remanded. I'll recall the matter of the People versus Rashad Young.
Alexander, on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
Yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So we could get your name?
Tandiana Yates.
All right. Ma'am, I'm gonna let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just gonna let you know, because you don't come into the court that way, ever. Am I clear?
Yes.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has a, yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm
Well-
just gonna let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court,
because I
and
feel like it was
I
inaccurate.
will
information.
listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information, because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this, because you kind of blurted that out when you had come busting in here.
And my apologies for.
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number, and it was to my sibling. You guys stated on.
If there are references to the case, ma'am, we thought about that.
Okay.
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily what is being represented to the court appears to be true. And we will flush it out at a hearing, because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I am not going to have a hearing on it right now. I will listen to
Okay,
you.
that's just that was just very inaccurate to me, and I just felt like the way that y'all did that was no. Somebody should have let me
Y'all
know.
did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No,
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem. Miss Cannon, do you want your cases called now? No, I'm good. I am so good, Miss Cannon. Are your people here? Oh, well.
Yes, Your Honor, they are here. They are ready and they are eager to just listen and learn from this honorable panel.
This courtroom hearing quickly turns into a serious, intense domestic violence case, where safety, bond conditions, and courtroom discipline collide. The case involves Rashad Young, a defendant with multiple active cases involving the same victim. As the prosecutor addresses the court, the concerns are immediate and severe. According to the state, this is not an isolated incident. Young has a companion assault case, another domestic violence case in a different county, and in this matter, he is accused of threatening the victim with a knife during an argument. The prosecutor describes the alleged incident in detail, claiming the defendant pulled out a knife, raised it, and brought it down toward the victim in a threatening manner. But what truly alarms the court is what happened after his arrest. While in custody, Young allegedly made 135 phone calls to the victim, despite a strict no-conduct bond condition. The prosecution argues that this repeated contact shows a pattern of control and danger, and asks the judge to increase the bond to $25,000 cash. Number 10%, citing serious safety concerns for the victim. The defense responds firmly. Young's attorney argues that the case is based solely on the victim's testimony, with no physical evidence of a knife. He also denies the phone call allegations, stating that no violation report has been provided and that the defendant claims he did not make those calls. The defense asks for a short adjournment to review discovery and requests that Young remain free on bond, possibly with a tether, emphasizing that he is employed and a father. But the judge is not convinced. The court points out that the calls were allegedly made from the jail using the defendant's personal PIN and occurred after he was clearly ordered to have no contact. Given the multiple overlapping cases involving the same victim, the judge expresses deep concern about continued contact and potential escalation. The ruling is swift and serious. The judge adjourns the case for 1 week but sets bond at $25,000 cash and orders the defendant remanded into custody. Additionally, the court revokes Young's phone privileges, stating that preventing further contact is now a priority. A hearing is scheduled for the following week to fully address the alleged bond violations. But the tension doesn't end there. Moments later, the court recalls the case after a woman, Tana Yates, forcefully enters the courtroom. Upset about what she believes is inaccurate information presented against the defendant, the judge immediately reprimands her, stating plainly that this is not how anyone addresses the court. Despite her earlier behavior, the judge allows her to speak. She apologizes, then insists the prosecution should have contacted her before presenting information she believes is incorrect. She claims the records shown on Zoom were inaccurate and expresses frustration that decisions were made without her input. The judge listens, but firmly pushes back. He explains that the prosecutor fulfilled their duty by verifying the information, and that, at least preliminarily, the court finds the information accurate enough to justify the remand. He emphasizes that this is why the system provides due process. A formal hearing will take place next week where all evidence can be examined properly. S. Yates continues to argue, questioning how a violation could occur without direct contact. The judge's patience wears thin. He reminds her that attempted or indirect contact still matters, and that the court is enforcing its orders to protect everyone involved. Then the moment explodes. When Yates turns away while the judge is speaking, he immediately shuts the exchange down. In a sharp warning, He tells her she is testing the court's patience, orders her removed from the courtroom, and makes it clear the discussion is over. The message is unmistakable. Court is a place of rules, restraint, and consequences. Emotions may be high, but behavior matters, and violations, especially in domestic violence cases, are treated with zero tolerance. As the session moves on, the judge regains control of the room, reminding everyone present that the courtroom exists to enforce the law, protect victims, and ensure fairness, not chaos. And with that, the case pauses, not resolved, but escalated, awaiting a hearing that could determine whether Rashad Young's custody continues or changes.